transfer of criminal case from one court to another under section 407 of Criminal Procedure Code. Why? Why I think to make this type of video? You know very well that in Naroda case, CBI has filed a charge sheet after completing investigations. Then, before filing the charge sheet, when they want to arrest the four accused, then there is a dispute between the state of West Bengal and the central investigating agencies. And definitely the entire scenario you have already seen in the different electronic media. What is the relevancy of this video? First, the question comes whether the CBI can arrest that person before filing the charge sheet. I think that the arrest is a procedure, and if the accused has not got any anticipatory bail, the investigating agency for the purpose of investigation and before filing of charge sheet, definitely they can arrest. Whether it is necessity or not, that may be disputed, but they can arrest. Now, when they complete the investigation and file the charge sheet before the proper court, when the bail has been granted, by that particular court, then the CBI came before the Honorable High Court and filed a petition under section 407 of Criminal Procedure Code, and in that particular petition, CBI want to transfer this case from one court to another. Now, before going to discuss anything, I want to tell you what is the prayer of the CBI. I have got the petition from a public domain. That is why I hereby produce this prayer for your kind convenience. Before going to read the prayer portion, first I have to discuss the heading of the petition. What is the heading? What is the heading of the petition? An application under Article 226 and Article 227 of the Constitution of India, read with Section 407, read with Section 482 of the Code of Criminal Procedure. This is the heading of the petition, and it has been filed by just a second. Filed by Central Bureau of Investigation Anti-Corruption Branch, Kolkata, represented by Superintendent of Police, having office at Nizam Palace, 2nd MSO Building, 4th and 14th and 15th floor, 234/4 AJC Bose Road, Kolkata, 700020. and it has been filed against just a second. Firad Hakim, alias Bobby, son of Abdul Hakim. Second one is Madan Mitra, son of late Josna Mitra. Third one is Shobhan Chatterjee, son of late Devi Prasad Chatterjee. Fourth one is Subroto Mukherjee, son of late Ashok Mukherjee. Fifth one is Sayyid Mohammad Hossein Mirza. And the sixth one is Mrs. Momota Banerjee. Seventh one is Molay Ghatak. Eighth one is Sri Kollan Banerjee. Then the entire petition has been described, and ultimately I come to the prayer. Prayer portion is very much important here. In facts of the circumstances stated above, it is most and humbly prayed that your lordship may graciously be pleased to issue a rule calling upon the opposite party to show cause as to why the particular case should not be transferred to and tried before this honorable court. Mind that word, tried before this honorable court. Call for the records, and after perusing the same and hearing the parties there to make the rule absolute and to pass such other order or orders as your honor may deem fit and proper. To declare the proceedings dated at the post-production of the arrest accused virtually before the learned court to be a nullity in the eye of law, pending the final hearing, disposal of the present honorable court may be pleased to continue the order dated 17th May 2021 passed by this honorable High Court. This is the prayer. Now, I come to the particular section, that is 406. That is the 406, 407. Sorry for this. 407 of CRPC. What the 407 CRPC says. Section 407 in Section 407 Criminal Procedure Code said the power of the High Court to transfer case and appeals. Power of the High Court to transfer case and appeals. Whenever the first subsection, that is subsection 1, whenever it is made to appear to the High Court that a fair and impartial inquiry or trial could not be held in any criminal court subordinate thereto, or that some question of law of unusual difficulty is likely to arise, or that an order under this section is required by the provision of this code and will tend to be a general convenience of the parties or witness, or is expedient for the ends of justice. It may order. What are the orders? That any offense be inquired into or tried by any court not qualified under section 177 to 185 but in other aspect competent to inquire into or try such offence, that any particular number 2, that any particular case or appeal or a class of case or appeal be transferred from a criminal court subordinate to it authority to any other such criminal court of equal or superior jurisdiction, that any particular case be committed for trial to a court of session, and that any particular case or appeal be transferred to and tried before itself. Very important. The last is very important. That any particular case or appeal be transferred to and tried before itself. Then the subsection 2 says the High Court may act either on the report of the lower court or on the application of a party interested or in its own initiative, provided that no application shall lie to the High Court for transferring a case from one criminal court to another criminal court in same session divisions, unless an application for such transfer has been made to the session judge is rejected by him. Number 3. Every application for an order under subsection 1 shall be made by motion which shall, except when an application is the applicant is the Advocate General of the state, be supported by affidavit or affirmation. When such application is made by an acquitted person, the High Court may direct him to execute a bond with or without surety for the payment of any compensation which the High Court may award under subsection 7. Every accused person making such application shall give to the public prosecutor a notice in writing of the application together with the copy of the ground on which it was made, and no order shall be made on the merit of the application unless at least 24 hours has been elapsed between the giving of such notice and the hearing of such application. When the application is for the transfer of the case or the appeal from any subordinate court, the High Court may, if it is satisfied it is necessary so to do in interest of justice, order that the pending and disposal of application, the proceedings of the subordinate court shall be stayed on such term as High Court may think to impose, provided such stay shall not affect the subordinate court power to remand under section 309. An application for an order under subsection 1 is dismissed, the High Court may, if it is opinion that the application was frivolous, vexatious, order of application to pay by way of compensation to any person who is opposed the application, and such sum is not exceeding 1,000 rupees, which may consider proper in circumstances. When the High Court order under subsection 1 that a case be transferred from any court for trial before itself, it shall observe that such trial the same procedure where the court would have observed if the case has not been transferred. Nothing in this section shall deem to affect any order of the government under section 197. This is the entire section of 407. So for the transfer of case, I want to tell here that For the transfer of case, High Court may transfer a certain type of case from one court to another subordinate to him. High courts by its own motion by or the application by the party, the High Court may transfer the case and try it by itself. It is very important. Try it by itself. That is under subsection 1, subclause 5, that any particular case or appeal be transferred to and tried before itself. And the word is very important. High Court may transfer this case from one court to another, subordinate to him, a class of appeal from one court to another. That is another thing. And High Court may transfer that case to it and try it before itself. High Court has his own power under this section to try this type of case if he thinks that it is so much important. And this is very much important. So entire 407, transferring of case, transferring of order, suspension of order, all things can be done. High Court, if it is saying, it may transfer this case and take it in its own motion. So from our advocate's point of view, this particular section, this particular subsection of this section is very, very important. And by taking the advantage of this subsection, the CBI has filed this petition. So now the High Court may take in its own course, and what will be the result of the petition you will see in the next few days. And so after seeing this type of petition, when I, being a student of law, I put this question to myself, whether in each and every media, the entire media, the all leading electronics media, they have said a caption. They have entered a caption and say that the CBI want to transfer this case from this state to another state. That is wrong. That is wrong. That is the misleading news. The CBI, by this petition, I have already tell you the entire prayer. CBI want to transfer this case from that particular CBI court to the High Court itself, not to transfer the case to the other. I think that this video or this audio visual conversation will go to the hands of media, and they will rectify this. All electronics media made this mistake. They are thinking that the High Court want to transfer this case from one state to another. No, the prayer is totally different. They have to rectify their mistake. So I think that the suspension of the lower court's order, whether the High Court can do it or not, the section also clearly said. Section also clearly said, High Court, whether the High Court can do this or not, that I think that I am not willing to disclose this right now. When an application, that is subsection 6, when an application is for the transfer of a case or appeal from any subordinate court, the High Court may, if it is satisfied it is necessary to do so for the interest of the order, that the pending of disposal of the application, the proceedings of subordinate court shall be stayed on such term as the High Court may think fit to impose, provided such stay shall not affect the power of the subordinate court to remand under section 309. So whether I think that king cannot do anything wrong, so a justice of a High Court, honorable High Court, or the senior advocates of our country cannot do anything wrong. They have to plead their own case. But as a student of law, as per my understanding, I have explained this type of situation in this way for your benefit. I think don't be misguided by these electronic media. They have given a wrong message. I think it is my personal opinion. It is not the opinion of the. If I have right to clear this before them, then I think that the entire society will be benefited. But I think that I have not get such right. So from this point of view, from this entire thing, that you will be learn from the lots of things. Well, I think that all in each and every proceedings, we are learning. We the advocates of the learning. We are not the we think we are I think that I am learned, but I think still I am learning. So I may be learned addressed by the others, but I think that I am learning. So learning process is very much important. I have discussed the entire section. The first thing that a high court, if it is saying that it may transfer this one case to another court subordinate to him, and they may also transfer this court to other to other court, and it may also transfer this court and try it by itself. What the CBI is doing is, previously I have also influenced by the media. I think that CBI is doing wrong. But after going to the entire petition, entire order, entire section, I think that the prayer is perhaps right. Thank you for this, and we will come to the next video and in any next time. Thank you.